Unlike copyright, registered designs, trademark and patents, which are creatures of statute, confidential information is a creature of the common law, contractual to some degree, and equity in other aspects. For information to be confidential, it must be proprietary. That is, it must have some value to you. You must keep it confidential and make sure that you can prove that the information is kept within your organisation and business secret in some way, shape or form. That is, not everyone within your organisation has aspects to it. And that should you impart this confidential information, you did so where the person receiving the information knew that they were receiving proprietary, confidential, secret information, and that it was not to be misused without your approval. Not being a creature of statute, there are no registration provisions for confidential information. The duration of protection is forever. For instance, with Coca-Cola, there's a secret formula. And that formula has never been publicly disclosed. Albeit, someone with a mass spectrometer might be able to find out what's in it, but that mere fact doesn't take away the fact that it's been kept as a secret. It's been kept as confidential information by the Coca-Cola company, and unless disclosed by them, that secret will remain with them. The form to transfer confidential information is again by contract. There not being any registration or any legislation, there are no other legal requirements than a contractual assignment of passing your information from one person to another. There are no international protection of confidential information. It is dealt with on a country-by-country basis. There's a number of steps that you can take to protect confidential information: entering into non-disclosure agreements, keeping adequate records of what information you create is confidential, making sure that only those employees within your organisation that have a need to know about the confidential information have that information. A case that we had a number of years ago was where a hairdresser who ran a number of businesses throughout the Sydney area kept their confidential records of their client details in paper form. It was a little bit before computers were used. One of their key employees left. There was no competition or restraint of competition clause, and that key employee literally went across the road, took out an empty shop and started competing against their head office. The client that we were acting for started receiving telephone calls saying, "Why are you contacting me? Why are you getting me? Have you moved? What's this new location?" And they were able to discover that it was the ex-employee who was contacting them. Obviously, the ex-employee had taken away the client's information. The difficulty that my client had was that in that particular organisation, everyone from the receptionist, the newest apprentice, to himself had access to the information about clients. It was therefore very difficult for that hairdresser to establish that they protected the details of their clients. Consequently, they were not able to succeed in any breach of confidential information against the particular employee that had stolen that information from them. So if you wish to protect your confidential information, you need to be able to show to a court that the information that you have was so important to you that you protected it. If you can't show a court that you want to protect that information, it will be very difficult to have a court come to your aid and after the event try to protect information which you yourself haven't taken the appropriate steps to protect over. In a larger organisation where there's confidential information, issue regular reminder to employers about their obligations to keep information confidential.